Good afternoon. Welcome to the Appellate Division First Department. As I call the calendar today, please ask for the time that you actually need. And remember that if the panel has additional questions past the time you've been allotted, we will ask them and you will have an opportunity to answer. We have read your papers and are familiar with the issues that underlie your appeals. For those of you here for the first time, you should know that the white light on the lectern will go off when you have 2 minutes left, or if you've asked for less than 2 minutes, it will go on immediately. I'd like to welcome Columbia Law students who are joining us today. When I call your case, rise and let me know who you represent and how much time you are requesting. People v. Tariq Jenkins. Submitted. L. Peter v. Darian M. Submitted. Gonzalez v. Navalis Tile Incorporated. You appear not to have an opponent here today. Do you want to address the court anyway? We'll give you 3 minutes if you wish. Okay. Park v. Butko is submitted. People v. Daniel Sims. Submitted. People v. Joseph Ergotano.
For Mr. Ergotano, Your Honor, requesting a total of 8 minutes with 2 minutes for rebuttal.
3, 6, and 2, and 3. AIG Property Casualty and Highline Construction. We have an appeal, cross appeal, of course. Right. Just, you don't want any rebuttal time. All right. And the respondents? Okay.
Appellant, respondent, Interior. You have 7 minutes and 1 minute for rebuttal.
There's some asymmetry here. You wanted 3 and 1?
3 minutes.
And 1 rebuttal. Okay. You wanted 5. Okay, you shall have it, both of you.
I'll take 5.
You want 5? Who said that? Well, I'm getting to you, don't worry. I'm sorry, you're respondent though, aren't you, counsel? All right, here we go. 3 and 1, 5, 4 and 4. Thank you. Carrero, Santiago v. Asphalt Green.
Tracy Frankel for the appellants. 6 and 4, please.
4 and 1 and 5. Kaye v. JRR Contracting. Counsel, you don't have an opponent here today. I'll give you 3 minutes if you wish to address the court. You got it. Dorton Capital Management v. Stylist LLC. 6 and 2 and 6. People v. Kameka Jones.
Good afternoon, Your Honor. On behalf of Jones, request 6 minutes and 2 minutes rebuttal.
5 and 2 and 4. People v. Mamadou Diallo. Submitted. Buckman v. 117 East 72nd Street. Five and 2 and 5 and 2. Marinac v. Marinac. You don't have an opponent, ma'am. It's customary. If you wish, you can address the court if you wish for 3 minutes. Very well. People v. Gero. 3 and 1 and 3. People v. Alberto Sanchez. Submitted. Smartmatic USA v. Fox Corporation. Granted. Granted. How much time do you want? 8 and 2 and 7. I think I'll take that one out of turn, counsel, unless anyone has any objections. We'll go with this case first. Is that okay? All right. Very well. So we'll start with Smartmatic USA v. Fox Corporation. Please.
May it please the court. Wynn Allen from Kirkland & Ellis on behalf of Fox. This case presents an extraordinary situation. The plaintiff in this civil defamation case faces an upcoming criminal trial for bribery and corruption.
The criminal trial is still scheduled for January 2027?
It is, Your Honor. Because of litigation choices that Smartmatic has made, the outcome of that criminal trial will have a significant impact on the damages claims asserted here. Indeed, this court has already recognized in a prior appeal in this case that the impact of the criminal case is, quote, plainly relevant to Smartmatic's claims and is an integral part of Fox's defense.
Of course, their argument is, of course, that the damage has been done. So the result of the criminal trial, how will that affect damages in this case?
In three ways, Your Honor. First of all, Smartmatic is seeking to hold Fox liable for over $800 million in lost profit damages running through 2035. A criminal conviction would establish a clear alternative cause for those future lost profits. Secondly, Smartmatic is seeking to hold Fox liable for $3 billion in lost enterprise value. A conviction would destroy that enterprise value because it would invalidate assumptions about the integrity of past revenue and projected future revenues. And thirdly, Smartmatic wants to tell the jury that it had a reputation for honesty and integrity in the industry, and a criminal bribery conviction would obviously undermine that. So we believe that in the interest of justice and fairness, the criminal trial should go first. We need to know first whether Smartmatic is guilty of these charges of bribery and corruption.
Also, one predicate. I looked on NISIS today. The summary judgment motion has not been decided, correct?
That's correct.
Okay. Do you have a rough trial date from Justice Cohen?
We have received no indication from Justice Cohen as to when trial would be, Your Honor.
Please continue.
But in all events, we believe that the equitable result here is for the court to stay this case and vacate the note of issue so that before Smartmatic can ask the jury to award it billions of dollars in damages, we can learn the outcome of the criminal trial and assess what impact it will have on Smartmatic's business and the multi-billion-dollar damages claims it's pursuing here.
That impact would be after the fact of their allegations as to what damage was done by Fox's alleged conduct, right?
It would not, Your Honor, because they're continuing to seek damages in this case running all the way to 2035. So they are seeking to hold Fox liable for over $800 million in lost profits between 2025 and 2035. Our argument to the jury will be there are alternative causes for those lost profits other than Fox's conduct.
You can still make that argument without staying the trial, right? Given that these allegations are out there and it's public record of these allegations.
I can, and my client most likely will, but it will certainly be more consequential if we know the actual outcome of the criminal proceedings.
Why? What makes it more consequential?
Two reasons. One is because an actual conviction of Smartmatic would result in certain debarment qualifications for Smartmatic in jurisdictions overseas. They will be legally prohibited.
That debarment would be after the fact, again, from the claims of what Fox allegedly did, right?
It will not be after the fact from the damages that Smartmatic's seeking. Again, they are seeking damages running all the way to 2035, both in the terms of lost profits and the lost enterprise value they're seeking here. So because of the way they pleaded their case, the outcome of the criminal case becomes directly relevant to the damages they're seeking because they're seeking damages so far in the future.
In the short term, what's more important, that you get the stay or that you get discovery related to the allegations in the federal criminal proceeding?
The most important thing is that we know the outcome of the criminal proceeding and discovery into the impact of the criminal proceeding. We think that requires a stay such that trial in this case doesn't occur before the criminal case and we can learn the impact of it. But otherwise, mainly what I would like to happen is we know the outcome of the criminal trial, which we'll know in January or February in 2027. We have a brief period to conduct additional discovery into the impact of those claims, and then we go to trial.
Sir, what would that post-conviction, hypothetically, discovery look like?
It would look like the following. First of all, we would need document production from Smartmatic relating to correspondence they've received from their customers about the impact that the conviction is going to have on their business. Are their current customers going to continue to do business with them? And are they going to lose future business prospects that they're seeking to hold Fox liable for in this case? In this case, they've identified over 90 opportunities across the world that they're seeking to hold Fox liable for that run all the way to 2035. We need to know if they hear from those customers that say, actually, we can't hire you anymore because you've been convicted of bribery and corruption in a federal criminal trial in the Southern District of Florida. We also do need to update the expert reports in this case because there's been a significant amount of damages expert discovery here that we will need to update in light of the criminal conviction.
So, counsel, did I hear right that there is still a motion for summary judgment pending?
That's correct.
Okay, is it fully submitted at this point?
It is fully submitted and argued.
And argued?
Yes.
Okay. You know, the trial calendar takes a long time. So, in my view, because you're also seeking discovery, I think that would be more important to you.
Assuming trial in the ordinary course would not occur until, call it this time next year, yes, the vacatur of the note of issue and the discovery would be more important. I just wouldn't want to leave a world where somehow trial gets scheduled before then, Your Honor. And again, we believe this discovery is significant and the vacatur is significant because of litigation choices that Smartmatic itself has made. It's Smartmatic, not Fox, that chose to seek over $800 million in lost profits running through 2035. It's Smartmatic, not Fox, that chose to assert an enterprise value of $3 billion based off historical revenue that might have been obtained by bribery.
So based on what you're arguing, it seems as though you're arguing that a lot of that will go to the damages, right? So what's to keep, what exists to keep from deciding liability?
Again, the trial in this case is all going to happen at once. Nobody's made a motion to bifurcate. So our arguments do go to damages. They don't go to liability. They are about the damages that Smartmatic is seeking here and the fact that they're
So
seeking...
why hold off the trial on liability, the issue of liability?
Your Honor, my understanding is the trial here, no one's made a motion to bifurcate liability from damages. And my understanding is that as of right now, both issues are going to be tried together. And
I'm
if
just
they're going
curious to follow up on Justice Michael's question, would that solve your problem?
It may or may not. I need to think about it a little bit, but I do know that if we're going to have a trial in which Smartmatic is going to be allowed to ask the jury for forward-looking damages beyond the criminal trial and criminal conviction, we should have the opportunity to tell the jury the outcome of that trial and the impact on it. I'd have to think a little bit more about whether that would solve the issue or not. And again, we do believe that the stay here is relatively brief and bounded. The criminal trial is scheduled for January of 2027. The judge in the Southern District of Florida has said on the docket that date is very unlikely to move. So we will know by early next year what the outcome of that trial is, be able to take brief discovery into it, and then proceed to trial in this case.
Well, the parties have a right to appeal. There are mistrials. You know, there could be a lot of contingencies that prevent the criminal trial from being definitive at some point in early 2027.
So I believe that if the jury returns a verdict, if there's a guilty verdict, then that guilty verdict will have an impact on the market and we can take discovery into that impact. If they're acquitted, then that will also have an impact and we can move forward with this case. I don't believe we need to wait for any appeals. If there's a mistrial and a retrial, then we might be back asking for more time. But again, there's every indication to believe that this case is going to proceed, that the criminal trial is going to proceed to verdict in January or February of 2027.
All right, thank you. You have time to rebuttal.
Thank you.
May it please the court, David Pope on behalf of the respondent. I want to emphasize one point that the court addressed, several members of the court, about the damage being done. Nothing that can happen in January 2027 can affect Smartmatic's reputation in November and December 2020 or thereafter after the defamation. That damage is
they're arguing it's more than just the intangible of reputation, it's rather the tangible of lost clients, and that affects their, you know, the damage that you can seek and obtain.
That would be future profits only from the conviction on.
Aren't you seeking damages for several decades still?
Up to 2035 in
Right.
lost profits, Your Honor, because of the continuing nature of the reputational harm.
Right, but the question is, in doing that and in charting the course that way, then if anything else comes up that impacts your reputation, then that is a part of what's damaged your reputation, not just what is alleged that Fox News did, right?
It would damage the reputation going forward. It can't change anything that happened in the past. It could.
But how do we have that
conceivably-
like date period in time in the future as, okay, this was alleged to have occurred on this particular date, and so we're damaged until 2035? Like, how do we know that that is the starting point and the ending point of the damage from the allegations?
We have executives who are experts in the industry. We have an expert who has evaluated the damages analysis, and basically.
So there's nothing that can happen in the intervening time that could present damage to the reputation, such as potential conviction?
Other things can happen in the future. Other things can always happen in the future in a defamation case, but we don't wait forever to see what might happen unrelated to the defamation that affects that company's reputation. Okay?
Is there a reasonable likelihood that the information they're seeking now could be used for impeachment purposes, depending, of course, on who was called at your defamation trial? But it may be beyond just the cognizable damages, but there may be value to the evidence vis-a-vis credibility determinations, more broadly, that the jury is going to be asked to make.
Are you talking about impeachment with a conviction of a crime, Your Honor, or impeachment with other facts from the criminal trial?
Well, I guess the ultimate prize they're seeking is to stay and await the outcome of the federal criminal trial. And so I guess it would be, assuming there was a criminal conviction, then the impeachment value of that conviction.
That is speculative to begin with. Number two, if they really cared about impeachment and using that in the civil trial, they would have sought a stay when the individual employees were indicted in 2024. But they are the ones who they would impeach, and they did not seek a stay to say, oh, we need to know if these 2 people or 3 people are convicted because we want to impeach them with that conviction. They would have filed that motion to stay at that time, not now. It belies the motives for this. We believe the motive is delay.
Counsel,
Go ahead, Your Honor.
if appellants were to move for a bifurcation of the trial between liability and damages, what would your position be?
I'd have to talk to my client about it, Your Honor. I can't say off the cuff what our position on that would be. What I can say is the case is 5 years old. The note of issue was more than a year ago. We've done a lot of discovery on damages and every other issue.
Counsel, let me ask you about a different bifurcation, which is, how do you defend the distinction in discovery between LA and Venezuela? I don't really get that.
The distinction in discovery in what?
Well, just that you don't get as comprehensive discovery, they don't get as comprehensive discovery concerning the LA incidents alleged. Isn't that, maybe I'm mistaken, I thought that was part of the special referee's ruling.
We're producing on the impact of criminal allegations, and this is an important point too. This court ordered us last year to produce discovery on the impact of any indictment, et cetera. We're doing that, we've done it, we'll update the production if there were a conviction. We're updating it between now and the time of trial, so we will give them that discovery. That is not an issue with us. As far as LA County goes, and whether LA County justifies reopening discovery, they've been seeking discovery on all bribery-related allegations since 2022. And they sought from LA County itself in 2024 in a public records request documents about alleged bribery in LA County. So they knew about that issue in 2024. All this, we're taken by surprise by these new developments. In our view, Your Honor,
I guess it's just for electronic discovery purposes. Shouldn't we include LA-centric search terms there?
We have run them, Your Honor. They want more is the issue.
Yeah.
I think Justice Marin, JHO Marin, is close to that issue. He decided it. Justice Cohen weighed in on it. He decided it. Those two know this case better than anyone, any jurist. They decided on those search terms. We're already running what we believe are comprehensive search terms on those issues and producing those documents. So that's just what I would consider a a minor issue about disagreement of search terms, Your Honor.
But that is an issue on appeal.
It is an issue on appeal, Your Honor. Our position is the search terms as ordered are sufficient. Another point I want to make, this is not likely to be, or it will not in any event be an 8-month stay until January 2027. That's when they want to start taking discovery, and I know at least a couple of you noted that. That's when they start. They have not said how long that's going to take. They also have said that the impact of any conviction would take time to develop. So they want, assuming the trial even goes forward then, it's been moved 3 times, it could be moved again. We've got a motion to dismiss pending. I don't represent them in that case. There is a motion to dismiss pending in the criminal case, so it may not go to trial at all, okay? There may not be a conviction at all. As Your Honor noted, there will be an appeal if there is a conviction. In the 11th Circuit, that could last about a year. If there's a retrial, maybe it's another year. We're going on and on and on. So, Your Honor, our position is we need to go forward with this case. Justice Cohen is closer than anyone to it. He knows the discovery. He knows the issues. He knows his schedule. He has summary judgment submitted. He'll decide it, we believe, we hope, soon, because we believe we're going to win on several issues, and then a trial date will be set. It is possible that a trial date will be set, as Your Honor noted, because there can be a long line. It may fall after the criminal trial, so be it, if that happens, but we shouldn't delay just to wait for that criminal trial. And we've been waiting to clear our name for 5 years.
Thank you, counsel.
Thank you, Your Honor.
Thank you, Your Honor. 3 brief points, and I'm happy to answer any questions. The first point is the key here is that Smartmatic is seeking special damages running all the way to 2035. And to do that, they have to show causation. They have to connect those damages to the defamatory statements made here. And we're entitled to point to clear alternative causation evidence. And this is a huge, big, significant, clear alternative causation argument that my client should be able to press at trial. Secondly, yes, a conviction would have impeachment value at trial. If any Smartmatic witness testified on behalf of the company, we obviously could impeach them with a conviction. And in addition, one of the individuals that testified is Smartmatic's corporate representative in this case is one of the individuals who is under indictment as an individual in the Southern District of Florida.
Didn't he plead the 5th all along?
He has pleaded the 5th in this. When we deposed him and some other people in this litigation, he has taken the 5th. There's been over 200 invocations of the 5th Amendment.
Do you expect that he'll change?
After a criminal conviction has been returned, he may or may not. If it's still on appeal, he might not.
It's their burden to prove damages, of course, and so it's less profound an impediment when a plaintiff may be pleading the 5th. You have to concede that.
Well,
then if a
it
defendant.
depends on the question they were taking the 5th to. So, for example, one of the questions we asked for them was, can you identify any of your past revenue that wasn't the result of bribery? And they took the 5th Amendment with respect to that question. So I understand that might hamstring some of the evidence that they want to present, but it also hamstrings our ability to really understand where some of the past revenues that they got came from that they're using to project their future profitability.
Sir, if we were inclined to disagree with J.H. O'Marin and Judge Cohen and authorize some additional discovery, wouldn't the better course be to deny the stay, allow for whatever limited discovery, and then down the road, if you feel a stay is necessary, to renew your motion rather than create the uncertainty for all involved, the courts and the parties, as to where this case is going on the New York State trial calendar?
So I'm okay with that as long as trial in this case happens after the criminal trial and a period for discovery after the criminal trial. So whether that's accomplished by staying this case until we're allowed to do that, or it's accomplished by vacating the note of issue and making sure a trial date's not set until after that period, I'm indifferent to that. I just need to know the outcome of the criminal case and what impact it's going to have on their business and their damages claims against my client.
Thank you, counsel.
Thank you.
All. Next case up is Gonzalez v. Navalis tile.
Good afternoon. Colby Forrest for the plaintiff appellant. So we're here to ask for a reversal, specifically for 240 subsection
Counsel, can
1.
you put the microphone a little closer? Thank you.
Importantly, the order correctly states that plaintiff met his burden on liability on his labor law 240 subsection 1 cause of action. However, the court does go on to state that defendants raised a question of fact regarding the distance, first, that plaintiff's foot fell, and two, whether there were safety devices that defendants could have provided. It is our position that the court improperly determined that the defendants raised an issue of fact on both of these points. Specifically looking at the distance plaintiff's foot fell first. Within the recitation of the law, the trial court stated that there was no bright line minimum distance. However, immediately after discussing Carmody's affidavit, the court reasoned that there was an issue of fact. If there was no bright line minimum regarding the distance plaintiff's foot fell, then there was no reason why that the measurements in this affidavit should have created an issue of fact.
So the measurement aside, your client said that perhaps there shouldn't be there should be planks on the rebars, but doesn't that defeat the whole purpose of the job to fill the rebar section with cement?
I would say that it would make the job more difficult, but I don't think it defeats the purpose. The plaintiff wasn't asking for the planks to cover the entire portion of the rebar, maybe just a small section to give him a firm surface to stand on, because without that, he was forced to stand on the wet rebar, which is naturally curved, smaller in dimension, so it increases the slipping hazard. Also,
But counsel, how would he still be pouring the concrete if there's something covering that part? Because it wasn't it to cover the pouring of the concrete was the entire section?
it was the entire floor, yes.
Right.
So the concrete was being poured from another area, and the plaintiff was leveling the concrete. So it is our belief that the plaintiff could have been moving the plywood backwards. Also, there could have been other safety devices provided in order to stop plaintiff from falling. He was forced to stand on top of this rebar, as I stated before.
Counsel, how do you deal with the contradictions in your client's testimony? For example, at some points he argued that he stated that he slipped on a piece of loose rebar, that the only reason he fell was because it was loose, but then at another point he said that he fell because the rebar was wet. So how do you deal with those contradictions? Doesn't that create questions of fact that preclude us from granting your motion?
Sure, we would argue that the plaintiff's testimony states that he was standing on loose and wet rebar. We believe that.
There was at least one point when opposing counsel said to him, so is your only claim that the rebar was loose? And he said yes.
Okay,
How
sure.
do you deal with that?
I mean, we would still say that it is both. I think there's a lot of testimony from plaintiff, and he is asked to recount the events consistently. And I think over the time he does say it is loose, also wet, and so it's our position that he does state that it is both loose and wet.
Thank you, counsel.
Thank you.
Next case is People v. Ergotano.
Good afternoon. May it please the court, Stephen Preziosi for Mr. Ergotano. Your Honor, this is a combination of direct appeal and appeal of the 440 motion. My first point is that trial counsel was ineffective for failure to make a motion for a trial order of dismissal for sufficiency, and specifically on the point of serious physical injury. And there are 3 points, 3 main arguments I have for this, where the people's evidence in terms of what I call in my brief the hypothetical question. That's 1. 2 is the medical records that the people relied on. And 3 is the people's loss of blood argument. Each one of those was insufficient to prove serious physical injury, which is an essential element of assault in the first degree.
The victim would have died if it weren't for medical intervention. How is that not serious?
There was no evidence of that. No one testified to that,
Testimony
and
to
there was
that.
no evidence of that.
Didn't the doctor
And-
was
testify
testimony.
to that?
And here's why I started with the hypothetical question, because this was the hypothetical question posed to their doctor, their expert witness. And I don't want to, it's replicated at page 9 of my brief, and I don't want to misquote it because there's several layers to it.
Well, just say it if you don't want to, whatever it
I'm
is.
gonna read it. I'm gonna read it. This is the question posed to the doctor. What would have happened if his bleeding was not controlled and quinones bled out, and if there were no medical intervention and the patient kept on bleeding, what would have happened to him? The doctor's answer, it's conceivable that he would have continued bleeding.
So you
Eventually,
take issue
what
with
would
the
have happened?
conceivable part? The
Sorry?
it's conceivable part? That's what you take issue with?
In part. That's just part one. That's number one. The doctor said it's conceivable. He didn't know. That is not proof beyond a reasonable doubt that there was a substantial risk of death. Part two of my argument is the medical records that were read into evidence by the people's expert, the doctor, replicated at page 6 of my brief. The medical records show no internal injuries, no injuries to any organ, no injuries to any blood vessel, 3 wounds. The largest wound was 3 centimeters, which is 1.1 inches.
He required blood transfusions too, right, counsel? He required blood transfusions.
3 units of blood, Your Honor. And I'm going to get to that. That's point
And
3.
he
loss of
also
blood.
had to relearn how to walk, right?
Well, there
Based on the injury.
That was his testimony. And our position is that he was malingering because in the medical records, his doctor
But that's a
stated,
jury question. That's a jury question. We can't decide that as a matter of law.
well, the medical records say this, Your Honor, that there were no extraordinary complications in his recovery. That was testified to by their expert. No extraordinary
Procedurally,
complications.
I don't know, in the wake of People versus Danielson, is the failure to seek a trial order of dismissal material anymore? Because you don't have to preserve your weight of the evidence argument. You still get that as of right before us. And as Justice Moulton just indicated, that if there is some variance between the testimony and medical records, wouldn't you be able to press that point on your direct appeal under a weight of the evidence review?
And that's why in my brief, Your Honor, I asked that this court take on the substance of the issue in the interest of justice under 470.15. Now, loss of blood. Your Honor asked about loss of blood. The testimony started on loss of blood, replicated at page 56 of my brief, is the doctor quoting a report from an ambulance driver. The DA asked him, what did you see when you came on the scene? I came on the scene, the victim was laying on the stairs and, quote, 1.5 pints on the floor. And they asked the doctor, what does that mean, 1.5 pints on the floor? The doctor's answer, presumably the blood loss. The people use that to leapfrog into the argument that he lost a third of his blood. Now, Your Honor asked about units of blood. 3 units of blood, 250 milliliters each, is 750 milliliters, less than a liter. The average man has between 5 and 6 liters of blood. That is not close to a third of his blood. Not a substantial risk of death. Let's go back to the definition of serious physical injury. Serious physical injury creates a substantial risk of death, protracted impairment of health. We know that didn't happen because there were no extraordinary complications in recovery.
Well, didn't he-
Loss or impairment of a bodily organ,
Counsel, hold
we
on
know that
just-
didn't happen.
Counsel. Chen has a
Wasn't
question.
there a lengthy recovering and physical therapy period?
He was in the hospital for several days, and I don't know how long his physical therapy was. I don't know.
Okay, thank you.
But that eliminated the majority of the definition of serious physical injury. The hypothetical question, conceivably, he could have. The medical records, no blood vessels were damaged, no organs were damaged, no internal injuries, no extraordinary circumstances, and the loss of blood was grossly overestimated. So there was no serious physical injury.
What about the fact that his blood pressure had dipped to 60/40?
His blood pressure was low, yes.
Isn't that a blood pressure tantamount to hemorrhagic shock?
There was no testimony. There's no such testimony.
Thank you, counsel. You have time to rebuttal.
May it please the court, Noah Shamma for the people. As far as serious physical injury, Your Honor, we provided 3 theories upon which the defense attorney would have recognized a motion to dismiss would have failed. The first of which is due to the blood loss. The people asked the following question just before the quotes that my adversary relied on. With regards to the injuries you told us about, including the amount of blood loss, if left untreated, would these injuries cause a substantial risk of death? And he answered yes. It is then that the questions regarding conceivable and everything took place. But that is more than sufficient as in terms of his opinion to make that out. In terms of the objective facts, I would ask Your Honors to look at the testimony that he did in fact have a 60/40 blood pressure and was traumatic hemorrhagic shock, which is actually page 20 of the doctor's testimony. The quote I gave was on page 28. So the bleeding was extensive. That's number one, and he would have died. Number two is regarding the long-term impairment of a physical function, which in this case, the defense on cross-examination got elicited that he went on SSI disability in 2017 because of the pain. He could not work. That was the reason he couldn't work. It was because of the stab wounds. They continue to hurt. On direct, on pages 106 and 107, he went through 4 months of rehab, returned to the hospital multiple times.
We noted all that. I want to shift gears for a minute. Defendant makes the argument that the video shown needs context, and therefore the trial court erred when and denied the defendant his confrontation rights when it disallowed questions of Quinones on cross about a prior incident between the 2 men. What about that?
About a prior incident between the
About a prior violent incident involving Quinones.
It was a subsequent incident, Your Honor.
Oh, it was subsequent?
It was subsequent. It was 4 years later. It was, and it didn't involve the same 2 people.
Okay.
It was,
Maybe I'm mistaken.
he assaulted a police officer was the allegation 4 years later. It was not a previous interaction that was the basis of this appeal between the 2. As far as the video itself, the last point on the appeal relates to whether or not there is anything in the video that shows something more. And the answer came out in both the 330 opinion and the 440 opinion. Both courts independently reviewed every available video and said that there is no additional evidence of what the defense is claiming exists. That, in fact, I believe that the court said it 5 different times in its opinion, that it just is conclusively refuted by the record that there is anything more than what is in that video of the crime, which establishes that the defendant came downstairs with the bag with the knife in it, unlocked the front entry door, and then stabbed the victim.
Can we talk about the missing witness?
As far
And
as the missing
not
witness,
granting the witness immunity?
absolutely, Your Honor. As far as the missing witness, I think it's important to note there's been no proffer of any kind in terms of what this witness would provide. The 440 itself, there was no affidavit attached even. So in addition to being unpreserved, because the defense actually never requested that immunity be granted, which I think is the most important point. It was actually the court that, in its exact words, as an aside, said to the people, you could always grant her immunity if you wanted to call her, because the people wanted an instruction from the judge saying, we want the jury to understand she's not a witness in this case. That was the only reference to immunity in the entire record. There was no request for immunity, and there's never been a proffer from anyone regarding what she could or would testify to. And ultimately, the one thing that the defense wanted out of her is something the defendant himself could have and should have testified to, which is what he himself knew, which is the claim underlying his justification defense.
Thank you.
Thank you, counsel.
Thank you.
Judge, I do want to address the failure to immunize this witness, because this is a
Was there a request to immunize the witness?
no, because the judge had already, he asked the people, why don't you grant her immunity?
Was
And
there
they
a
said
direct-
no.
Was there a direct ask?
No, because he had already refused. They had already refused to grant immunity. Why would we ask when they said no? Under 50.30,
Preserve the
we need
claim,
their
perhaps.
consent.
You might have asked so as to preserve the claim.
Yes, trial counsel might have done that. Now, their failure to grant her immunity deprived him of a defense. She was the live-in girlfriend of Mr. Ergotano at the time.
With regard to that issue, how is what she has to say relevant on your client's reasonable belief that imminent danger, that he was in imminent risk of physical harm? What testimony would she have to his subjective belief?
She would have the testimony that she told Mr. Ergotano that her, the victim here, Mr. Quinones, her ex-boyfriend, was in the habit, was violent, and carried a knife.
What did that have to do with what happened in the day of
Because
the
that went
incident?
directly to Mr. Ergotano's state of mind. And
How
it
does
would've-
that
would've played
refute,
in-
what import does that have on your client going down and engaging in stabbing the complaining witness?
Well,
Whatever she knew about him in the
let's
past.
put it in context, Your Honor. Mr. Quinones had already broken into the building and was directly banging and kicking on their door.
Not in the apartment, right?
Yes, he was outside of their apartment.
Right, but then this, but
Then
just let-
when
let's-
someone
let's-
threatened to call
Let me
the
finish,
police-
let me finish. The stabbing incident occurred in the vestibule outside of the entry door.
Downstairs in the- in
Right,
the
not at their front door, right?
Correct.
Okay.
All right. Mr. Ergotano's state of mind is relevant because if he believed that Quinones was violent and carried a knife, that would have given him justification
To go outside of the
for
apartment,
carrying-
downstairs
for
into the
carrying a knife
vestibule and
and
to stab him?
possibly to defend himself
Got it.
as part of a justification
How
defense.
does that give him justification for opening the door, which the victim was not seeking to pass by?
He was. He had already broken into the building. And now when someone called the police,
was
threatened to call the
outside.
police,
He was
he
outside.
left.
Okay.
And it was
Got it.
attempting to re-enter.
Thank you, counsel. Thank you both. AIG Property Casualty and Highline Construction.
May it please the court, my name is Gerald Kirby. I represent the defendant in this case and the appellant respondent, Sammy's Interior Painting. This is involving the denial of the motion for summary judgment by Sammy's. It is Sammy's contention and our contention that there was never any direct evidence of what plaintiff alleges. Plaintiff is very clear what he's alleging. An employee of Sammy's struck this sprinkler head and caused this water to discharge.
No
There's
one saw
absolutely-
that happen, correct?
Excuse me?
And no one saw that happen?
Absolutely no one. There's no evidence and no physical evidence of that ever happening. So they fall back on, and our argument is on duty, okay? There's no contractual privity at all with my client and the owners of the apartment where the damages took place, and they're relying on one of the Espinal exceptions. They're saying as a non-contracting party that my client launched some type of force or instrument of harm to cause this incident. But the fact of the matter is, there is no direct evidence of any evidence whatsoever of my client.
Well, this
or an
also
employee.
touches on the indemnification claim, so that it's an issue, it's a factual issue that affects what you're talking about and also the indemnification claim that they have against Sammy's, which is, doesn't Rooney's testimony and Mr. Markovich, or the fellow from Sammy's, your client, doesn't that testimony show that Highline had nothing to do with the painting work? And the painting work was proximate to the sprinkler that discharged the water. So therefore, it's process of elimination, issue a triable fact concerning Sammy's potential negligence.
Judge, my answer to that is, as the respondent on the contractual indemnification claim, that's been briefed. That contractual indemnification agreement is in direct contradiction with the general obligations law. It specifically says that they want Sammy to indemnify them.
Yeah, but we've held that where there's no showing of negligence against the person indemnified, the entity indemnified, that it doesn't run afoul of the general obligations law, as long as there's no showing of negligence against that indemnified party. That's Kraus, it's even an ITRI, or it's which is the case you cite.
Your Honor, but the motion is against, there's no evidence to invoke the indemnification clause because it specifically says that indemnification gets triggered when there's a breach of the contract. The breach of the contract, I would concede, would be if my client was found liable or negligent for this action. But there is no evidence of that. There's nothing in the record which shows that my client launched this instrument of harm. They try to piggyback it with the res ipsa loquitur theory, saying that my client, because they were in the area of the stair hall at some point during that day, that gave them exclusive control over a sprinkler head on the wall. It makes absolutely no sense whatsoever. So they're trying to piggyback one thing on top of something else. But the bottom line is, where is the evidence that my client hit that sprinkler head and caused this to happen? That's
Thank you, counsel. You have time in rebuttal as well.
Okay, thank you, Judge.
Good afternoon. May it please the court. My name is Peter Prokowski. I represent Highline. I'll just make one brief point with respect to Sammy, and I want to move on to the summary judgment motion that was against Highline here. There is a separate contractual indemnity, which is separate and distinct from the issue about the duty argument they're making with respect to the direct claim. So if the court was inclined to consider that, there's still a question about whether they owe contractual indemnity to the extent Highline established that they were not negligent moving forward. Reviewing all of this, I think the biggest problem is we got the cart before the horse here. We have all these rulings and all these decisions and motions going back and forth, and we don't have the critical issue determined yet. And that is, what was the cause of the sprinkler leak? This is a classic case, battle of
With
the
respect
experts.
to Highline's very broad indemnification of the knight and plaintiff.
Has to arise out of the work.
What's that?
Has to arise out of the work.
Yes, that's broad.
It is, but when you have two experts saying this potentially was an installation or a manufacturer, sprinkler systems fail. So if a fact finder says, and I understand the fact that it seems to suggest one way, but when you have two experts sitting there saying, we can't rule out the fact this could be installation or manufacturing that caused this sprinkler to fail.
But
that in and of itself.
Wasn't there I guess a checkup on all the sprinkler system just shortly before this happened?
But even so, we have these experts who went and inspected what was left of the sprinkler system, and they're saying we can't rule that out. And those are all arguments that could be made in front of a fact finder. But the question I think on summary judgment is, as a matter of law, based on these expert reports, can the trial court conclude that there's no question at all that this arose out of the renovation in order to have contractual indemnity on behalf of AIG? I think that's what the problem is. It's funny because I'm reading from the actual decision of the judge. It's page 104 of Highline's record on appeal, page 15, and he says, but as Mr. Lambert said, it would really be a stretch to say that we can't say that it arose out of or was related to the renovation work. I'm comfortable saying that that's been established as a matter of law. We all know the summary judgment standard. You view the facts in a light most favorable to the non-moving party. You give all reasonable inferences to the non-moving party. We have two experts here questioning, and AIG didn't even have their own expert. They relied on an expert from one of the co-defendants to say, this was definitely something that was a touching of the sprinkler head. But I think that the trial court made a mistake here by saying we're concluding as a matter of law that this could only have been from a physical touching of the sprinkler. I think the two experts create a question of fact, which question is going to resolve everything. This is like we need to get the answer from a jury as to what caused this. Was it a physical touching or something else? And if it was something else, there's the potential that it did not arise out of the renovation. I concede the fact that it's an uphill battle. I understand that. But as a matter of law, I think there's enough to take this to a jury. And I think the trial court erred in finding as a matter of law that this arose out of the work without that definitive.
Does it follow then, counsel, that we should not grant, or we shouldn't reverse the Supreme Court and say that, in fact, Highline is conditionally should prevail on its indemnification claim against Sammy's? I mean,
Isn't that the problem?
It's good
Because
for
it's
the,
inconsistent. I find that to be the problem. It's another problem.
so we shouldn't grant you, we shouldn't give.
It has to be both or neither. So if the court is going to uphold the order for AIG, then it should have granted the order with respect to Highline for the conditional summary judgment. Or both of them should have been, well, this is a fact question. A jury has to decide that. That's the inherent problem, I think, is because we have the inconsistent orders. We submit, first off, I submit that I think it's a fact question that has to be brought, but to the extent that this court is going to uphold that initial order, I think then the Highline contractual indemnity order has to be changed too. Thank you.
Thank you, counsel.
Good afternoon, Your Honors. May it please the court, Larry Lambert for AIG. The order granting AIG summary judgment against Highline must be affirmed. The indemnity agreement is clear that Highline is required to indemnify unit owners for any and all damages that occur that arise or relate to the renovation work. Negligence is irrelevant. You don't need negligence as long as it's from the work. And there's overwhelming evidence that occurred from the work. First of all, Highline admits it. They don't quiet on that. They admit it. In their own incident report, they said that the sprinkler head activated while Sammy's was using a knife on the wall where the sprinkler head was located. The owner of the apartment, Knight, they admit it happens it happened during the work. They submitted the expert report of Mr. Capuccio, who said that the sprinkler head activated when Sammy's took a knife and either went underneath or
Was
hit.
FSR's expert, wasn't it? Mr. Capuccio, wasn't he hired by FSR?
And the Knight,
by
they
the
both
plaintiff.
used it, exactly. And they said that this is very important. They said that
But the fact that it happened at that time doesn't establish that that was causation.
wait, if they took a knife and doesn't establish causation?
The fact
Well,
that they were working with a knife in that area doesn't establish.
but
that
Mr.
that was
Capuccio tied it
Excuse me,
together.
that doesn't establish that that means that their presence there caused the malfunction.
But all the other evidence along with that does. All the other evidence. You have Mr. Capuccio who said that it happened, their knife hitting the fusible link. Sprinkler heads just don't go off, okay? It's either heat or they're hit. Mr. Capuccio also said that he eliminated other things such as installation issues, such as damage to the head. There was no water pressure issues. This was the only sprinkler head, not only in the apartment, but in the whole building that went off. Is it coincidental that as they're working with knives, which they shouldn't have been working with, by the way? The bottom line is these two Sammy employees were working with knives on the wall, okay? They were told they were never allowed to use those knives. Their own owner said it, okay? That they were not good at doing stuff with knives.
They weren't good at
Right, they should.
skimming, but they were okay at hole patching. That's what I thought. That
They're not, well, it's a knife. It's the same thing. You're using.
No, but it's a different problem. Skimming is a more comprehensive treatment of the wall, I take it.
Okay, but they were seen using these metal knives a few minutes before the sprinkler head went off. Okay, the resident manager said that the sprinkler company came. There was nothing wrong with the sprinkler system. This was the only way it could have happened. These were the only people in the unit. This unit was not. There was nobody in the unit living there. Okay, and this was the only head that went off. It's clear. You got to put pieces together. We live downstairs. This is the reason that you have indemnity agreements and alteration agreements, is to protect unit owners from this type of work. Yeah, the fact there's no eyewitness. Why are there no eyewitnesses? Because Sammy's owner specifically said if they said that they hit it, they'd be fired. Of course they're not going to say that they hit it. There's no other reason to say that it went off. And that the experts that they speak about, their own experts, you know what their opinions are? I don't have an opinion. I can't make an opinion. Mr. Capuccio has an opinion. They just say it might have been, there's an AV room next door. Maybe it was from the AV room. Do they know whether the AV room was even operating? No, it was not operating. There's no evidence. There's only...
The theory was that it was the AV room and something else that maybe caused too much heat that caused this particular sprinkler head to go off. Was that ever quantified or in any way in their report?
No, of course not. This is all This is not scientific evidence. This is conjecture by experts. You have an expert that clearly states what happened, and then you have experts that have no idea what happened. You have them at the scene. Yes, I have no eyewitness. That is true. But every other factor says that they did it. They were there using metal tools. A metal tool caused it, and that's And that's why, remember, you don't need negligence just from the work. What else could have done it if it wasn't from the work?
Thank
There's
you,
nothing in
Counsel.
the building that did it. That's
Thank you.
all we have to show, the
You
work.
made that point very forcefully.
Thank you,
in
Your
brief.
Honors, appreciate it.
May it please the court, sorry, let me lower this. May it please the court, Maureen Pecknick on behalf of defendant respondent the Knight. Our brief is in response to Highline's appeal. I think the record speaks for itself in that Highline, pursuant to the contract as Highline as the general contractor and the Knight as the unit owner, under section 9.115, we are owed indemnification. Highline has been providing that for us. There is no evidence whatsoever contained in the record to establish the Knight was ever negligent. They were not on site, as plaintiff's counsel just pointed out, to your honors. They did not direct or control the work. They did not provide materials or equipment, and the contract speaks for itself. Thank you.
Thank you, Counsel. Okay.
Judge, very quickly, the affidavit, and you can see from Judge Moyne's decision, he was so skeptical of the Cappuccio affidavit. And why is that? Because Cappuccio gives this very distinct conclusion, saying that the only reasonable cause of this loss is that someone struck the fusible link within the sprinkler head and broke it, okay? And the judge is saying, well, where's the fusible link? How could you make that conclusion? He even says in his affidavit that there was no physical evidence on the sprinkler head itself demonstrating that it was struck in any manner. Yet he still comes back to the fusible link, which was never recovered. Nobody ever looked at it. And that's what that Cappuccio affidavit is all about. And this court has been very critical in its decisions on a lot of these subrogation claims of these experts coming in with these totally speculative conclusions, but not based on any facts. How can he say that something struck the fusible link breaking it when he never looked at the fusible link to come to that conclusion? That is what Justice Moyne was, and the other experts never came up with the causation, and they said you can't without looking at the fusible link, and that is the key item, the key piece of evidence in a sprinkler head, whether it's a product defect or from heat.
Thank you, Counsel. You have made that point. Thank you. Thank you all.
Your Honor, could I reserve a minute for rebuttal?
You weren't, you're AIG. You're not a cross appellant, are you? Thank you, Counsel. No worries. Carrero, Santiago v. Asphalt Green, Inc.
Good afternoon, Your Honors. Tracy Frankel for the appellants Asphalt Green Inc. and Coach Terrence Brown. I'd like to focus my attention right now to some of the challenges that the plaintiff raised, one of which was failure to warn that they would be playing basketball at recess and failure to warn that the ball hit off the rim. With respect to the failure to warn that a game was being played, that's unnecessary because, as the plaintiff herself had identified, that was the reason why this coach was hired. Were
there certain times at the recess period that basketball would be played or other things would be played on the basketball court?
Recess had different stations where multiple games could be played simultaneously. And this coach's
And that was the usual course of practice with recess?
That's correct. And so it was literally this coach's job to play basketball, and the plaintiff had admitted that she was aware of that. With respect to the plaintiff's suggestion that every time a ball hits a rim, somebody should yell out, watch out. That's not a reasonable burden to place on anyone, but amateur players, most of the balls are going to hit the rim and go off.
Counsel, in your brief, you say that being hit with a ball was a common risk when children were playing basketball. Would it matter if the ball that hit the plaintiff was thrown by an adult?
It doesn't, and that's one of the arguments that the plaintiff makes. To the extent that we don't know who took the shot, or there may be conflicting evidence as to whether it was an adult or a child, none of the case law is dependent on the age of a party. And with
But
Well,
how
what
it
about
was
the fact-
handled, I'm sorry.
I'm sorry. What about the fact that the coach first said, or at one point said that he threw the ball, and a later point said a child threw the ball? Does that have any bearing on on the credibility of your clients?
It's not a material conflict because it's literally the coach's job to teach children how to throw a ball. And so whether he threw it at that moment in time or a child threw it at that moment in time, it's not negligent or unreasonable for him to have done
Well,
so.
let's obviate the conflict because it's your motion, so we'll view the evidence in light most favorable to the plaintiffs, right? So viewing the evidence in light most favorable to the plaintiffs, it was the coach who shot that ball. Is that fair?
Assuming that is the case, it's not unreasonable behavior or negligent for a coach to throw a ball, to show children how to throw a ball. That's their job as coach. If they didn't need a coach and they just wanted children to play, then you could say,
Counsel,
you
that
could only
absolutely sounds right to me anyway, but is there any dispute about the proximity of what the plaintiff was doing? How close was the plaintiff to the basketball game?
10 to 12 feet, and I believe that that was not disputed
Not
by
disputed,
any,
right?
not disputed by any party. And the plaintiff was a teacher's aide who was responsible for monitoring the stations at the site. To the extent that she says that she couldn't hear or observe that basketball was being played behind her, then the argument fails, their argument fails, that one person saying heads up would have prevented the incident from happening. If she can't hear an entire basketball game, then one person isn't the argument that I would say wins the day. With respect to duty...
Sorry, is there anything in the record that suggests, and this goes back to something Justice Michaels asked you earlier, is there anything in the record to suggest that the coach, either basketball generally shouldn't have been played at that time, or that the coach himself shouldn't have been engaged in basketball at that time?
None. In fact, the school specifically brought Asphalt Green in to create games of play, and they mapped out prominently the basketball court as one of those stations that was permissible. So even if they weren't there at the start, they were expected to be there. And when you have your back turned and you make a point of looking to your sides, but you also make a point not to look behind you, that's something that I think undermines a lack of awareness, purposeful awareness or indifference, whatever it is. It shouldn't undermine a motion for summary judgment where they have an established duty and there's been no act of negligence on the part of the coach.
Well, the questions of duty and breach, we'd be looking at your clients. If we're going to look at the conduct of the plaintiff, then we'd be going into the assumption of risk realm, right?
Sure, and they're separate arguments. With respect to duty, the plaintiff challenges that the contract presupposes that they would be working together for safety. However, that's not really how contracts work. You can't presuppose. People bargain for the duties and obligations that they're going to undertake. And in this particular case, and as is reiterated in the plaintiff's own complaint, when they say the coach's duties were to the basketball itself and to the game. So there's nothing in the contract that says that they're required to supervise the teacher's aides. Certainly, I don't think any third party would agree to supervise employees of a school district.
And there were no allegations in the complaint that there shouldn't be a basketball game occurring at that time, correct?
I'm sorry, I didn't hear.
There's nothing in the complaint, no allegations that there should not be a basketball game going on at that time?
That's correct. Now, with respect...
Thank you, counsel. You have time to rebuttal.
Thank you.
May it please the court, my name is Jay Breakstone. I'm here on behalf of Maria Carrero Sanchez, who's the plaintiff.
Counsel, what's the theory of negligence here if all of these sports were to be occurring at the same time in this area?
The theory of negligence is very, to me, is rather simplistic. And it arrives, it's so simple that in the original contract between Asphalt Green and the district, it talks about doing everything safely, operating safely in the environment that they knew. And if that environment involved a 10-foot gap between basketball courts, they agreed to not only protect the people that they were taking care of, the students they were taking care of. Remember, we're talking about elementary school students here.
So the simple answer
sorry.
that you're, the simple duty that you're, or a theory of negligence that you're talking about here is to not hit someone while they're on a basketball court? Is that it?
It's even simpler than that. It's because anything could have happened on that court. It could have been dodgeball or something. In fact, it might have been, but we don't know. The simple theory is that you operate within the environment in a safe manner. That's, if you read the contract between Asphalt Green and the school district, that's exactly what we're talking about. We're not talking about a basketball court surrounded by 100 miles of nothingness. We're talking about an elementary school.
No basketball court within the city of New York would meet those parameters, right? The basketball courts are going to be in a setting where there are other...
Your Honor, you took the words right out of my mouth. If they're good words, I adopt them, and I do. But you're absolutely right. This is an urban basketball court. This is an urban playground. This is an urban not after school, but during a recess period. And if we go through this...
Right, and with that though, counsel, isn't it sort of normal that somebody may potentially get hit with a basketball while on a basketball court?
Your Honor, yes. The same way it's normal that someone in a golf course can get hit by a golf ball. The interesting thing to me here is that the defendant, the actor defendant as opposed to the corporate defendant, says that if I were playing basketball and I saw the ball ricochet off the hoop, I would yell, "Watch out!" And he never did that. If we take the first...
What does that matter, though, in terms of the
Because it would have caused, it might have caused...
She said she didn't hear any basketball
Oh, no,
being
she didn't
played.
say that.
Oh.
What she said was she was concentrating so much, she didn't realize they were playing basketball behind her.
She didn't hear the dribbling of the ball?
I guess not.
Let's talk about the
guess
plaintiff's
not.
status as a supervisor of recess for a minute. I mean, her job was supervising students. So doesn't that put a charge upon her to be aware of her environment?
Well, of course it does. But her environment when she took the field was that there was nothing behind
Just
her.
them, the double dutch or the jumping rope that she was supervising. That's all
in
she
the
was
record.
supposed to look for?
That's in the record. And a jury, Your Honor, might find that the situation that you described, that she should have been aware it was going on behind her, that might be the case. But for a motion for summary judgment, there's a question of fact. I know it's a question. I'm sorry, Your Honor.
What was the breach of the duty here? Was it the fact he took the shot? Was it the fact he didn't yell out the warning?
Well,
any
according
number of things?
to him, if his original story is true, if a jury finds that his original story is true, that he took the shot, he admits that he should have yelled out, "Beware, watch out." What does it take? A split second, turn around and move to the side?
But is
Not
that a
get hit?
requirement like in golf, and then the ball flies, so you say 4?
Your Honor, with due respect, and you know when I say in due respect, what I'm going to say is I think it's a greater duty in that tight situation. In golf, you've got an entire golf course. And without going into the Court of Appeals decision about golf balls and 4, and I know I shouldn't have mentioned that.
Well, I guess maybe the danger, though, is greater with a golf ball given its size and velocity compared to a basketball. Because I'm not familiar with any case outside of golf that imposes a duty to warn that the ball or other apparatus used in the sport is leaving the field of play.
Look at the damages here, and the fact is that let's just take the individual defendant's words, right? Let's make him the expert. Let's say that he's the one who is operating under this contract, and he says that I would have had a duty to warn if I was doing it. And we don't know who was shooting that ball. And a jury might decide that there's a reason we don't know who was shooting that ball. In fact, this individual cannot even identify the student when he comes back 5 years later, like 5 years later, and says, no, I didn't do it. Some student did it, and I don't know his name.
Thank you, counsel.
Thank you.
Just very briefly, Your Honors.
Counsel, why wasn't there a duty for the coach to yell out something when he saw that it was ricocheting?
Well, it's certainly not a requirement in any game of basketball to do so.
Well, but if the contract said there's an agreement to run the recess activities safely, why wouldn't that come within that?
There's nothing unsafe about a ball that hits off of a rim and the game continuing to be played. That is the normal course of basketball play. What's not the normal course of basketball play is to yell out every time a ball hits a rim, which is every 3 seconds of a basketball game, and then you'd have no coach being able to speak anything because their voice would be gone. So it's an impossible burden for anyone to place on a coach or children playing the game. But with respect to their theory of negligence that everyone should operate safely, the court had already found this to be a routine shot. And so with that finding, and that was as a matter of law, and counsel and the party, the plaintiff did not appeal from that decision, there's nothing on the record that indicates that unsafe conduct was taking place on the basketball court, nothing but routine conduct. Thank you, Your Honors.
Thank you, counsel. Thank you both. Counsel, oral argument is over. Thank you.
I know, if there's a mistake.
Counsel, thank you. You can retire now. Thank you. Kaye v. JRR Contracting.
May it please the court, Christy Kenzeg, on behalf of defendant third-party plaintiff appellant JRR Contracting. The lower court's order should be reversed and a default judgment should be entered against the third-party defendant, Ergotano. Contrary to the lower court's findings, the motion was timely, third-party defendant was properly served, and the motion was adequately supported with personal knowledge. As far as the timing issue is concerned, this is a default motion against a third party, and liability has not been assessed in the main action, so the one-year time period does not begin to run and has not yet run. As far as service, JRR's motion on appeal establishes that the Secretary of State was served, personal service was attempted, and we then realized that the business was not associated with its prior address. A mailing was later also sent. And then evidence, the court held that an affidavit of merit was required. However, we had the plaintiff's deposition transcript and the third-party plaintiff's deposition transcript, as well as the contract between the third parties. Based on that, the order should be reversed and the default judgment should be granted. So unless there are any questions, I'll rest on my brief.
Thank you, counsel.
Thank you.
Dorton v. Capital Management, or no, Dorton Capital Management v. Stylist.
Good afternoon, Your Honors, and may it please the court, Rory Schneider on behalf of the appellants. This court recently held, in this case, that the court had reversibly erred by requiring production of Mr. DePatrone's devices because the defendants had failed to show that he possessed what this court referred to as information crucial to a key issue.
I was on that case, and we were concerned, weren't we, with the absence of compliance with the Hague Convention? And so here, right? I mean, so here, then it went back to the trial court and he proceeded according to the Hague Convention.
Well, the non-compliance with the Hague Convention was only one of the errors on which this court.
Also, that was more about phones and electronic devices. This is a deposition.
Correct, but the rule that was the only form of discovery that was at issue in the prior appeal. But the reference to what the court said about the record was that it was deficient to demonstrate that Mr. DePatron.
Well, the record has evolved, right, since further discovery has transpired.
No, in fact, the record on appeal here is virtually identical to the record that was available at the time of the earlier appeal. All defendants cite to is a single text message that was produced after the earlier appeal. And what that text message shows is that plaintiffs, our clients, reported to Mr. DePatron merely that an audit was ongoing and that they, the plaintiffs, were going to terminate the contracts at issue. Mr. DePatron doesn't even respond to that text message. So that text message certainly does not show that he possesses crucial information to a key issue in the litigation. In fact, if anything.
But then in the motion to seal, weren't more evidence or indication of Mr. Patron's involvement come to light?
No, Your Honor. In fact, what the trial court originally held when defendants originally moved to compel Mr. DePatron's deposition was that even if he pulled the strings and wielded influence, it still wouldn't matter. Why? Because the defendants have deposed multiple senior high-ranking officers and board members of both plaintiffs' entities, along with the corporate representatives of both of those entities. And opposing counsel conceded below when the original motion was made.
But the question is really about Mr. DePatron's sort of authority and control here, and what they're seeking is to depose him about that. That is particularly within Mr. DePatron's knowledge, correct?
It's not. Well, two things.
He doesn't know how he controlled the company?
Well, respectfully, Your
Or did
Honor,
not?
This case is not about Mr. DePatron. It's not about his role.
Well, I know what the case is about. The case is about what caused the contracts to, what caused the end of this business relationship, right?
No, in fact, it's a claim by us for breaches of contract and fraud. So the focus is actually supposed to be on defendant's conduct.
No, but they're saying that's pretextual. And Mr.
Exactly.
How do you pronounce Mr. DePatron's name? How do you?
I've gone with DePatron. Yeah.
So we've been basically just saying it right.
Yeah. Exactly.
I have a procedural question for you.
Your Honor.
Did you see this letter? And did you get a chance to beef about it to the court before the court signed it?
We did not, Your Honor.
You didn't see it at all?
The sequence of events was that as a tack on to a motion to compel Mr. DePatron's deposition, they asked the court to grant a letter of request. They didn't append that letter of request. And so when the trial court issued the order that's on appeal, he said, submit me the letter of request for me to sign, and to do that by email by a date certain. And when that happened, we immediately wrote to the court and we said we are going to appeal, but in the interim, we'd also like to be heard and to make objections to the content of the eventual letter of request that was submitted. The trial court ignored that request.
Did you know that the 5 categories that are specified in the letter would be contained within it?
No, Your Honor, we did not. Of course, when we saw it, we did ask to object and be heard about its overbreadth, because again, Your Honor, the letter of request on its face, at minimum, 4 of the 5 topics set forth there, in addition to just being wildly overbroad, are absolutely irrelevant to the issues in this litigation. And they certainly don't concern information that's crucial to a key issue in the litigation. So of course, we submit that the letter of request shouldn't have been granted in the first place because they haven't shown that Mr. DePatron possesses unique and crucial information to a key issue. But if at minimum, we should have been heard to address the proper scope of what the letter of request that eventually did issue.
Is it an indispensable element of a request for discovery in a country that's a signatory to the Hague to demonstrate that the information sought is quote unquote crucial?
Yes, absolutely, Your Honor. And that's established in the prior appeal in this very case. And was built on several prior decisions of this court in Azria and Khan and multiple other ones. So that absolutely is showing that defendants needed to have made. And what happened here is if you look at the trial court's order, Not only was that an about-face from the trial court's original position with respect to whether Mr. DePatron should sit for a deposition, you'll find nothing in the trial court's order that addresses what the appropriate scope of discovery should be, what the scope of discovery that's already been taken, because had the judge considered the scope of what's already happened here, there's been extensive discovery. Multiple high-ranking officers have sat for depositions, and my opposing counsel conceded below. What's at issue is a corporate decision to terminate these agreements, and the individuals who had authority and in fact made that decision have testified here. They don't need Mr. DePatron's deposition, and they certainly haven't shown that there's any gap in the record that he can fill.
Thank you, counsel. Your time in rebuttal.
Thank you, Your Honor.
May it please the court.
Granted.
Thank you. May it please the court. I would just like to address a question that you, Your Honor, raised in regards to did they have the opportunity to review the letter of request prior to its submission? And I think that the timeline of that, I think, is a little bit different than what counsel referenced here today, is that when we filed our motion for a renewed request for the motion to compel, we asked for two different alternative remedies. The first would be to compel Mr. David to have Dorton produce him as a witness. The court denied that. In fact, in line with what this court actually ruled in regards to his electronic devices, it happened actually before you even came out with your ruling. The alternative request, though, was to submit a proposed letter of request to the court to approve so that we could send it to the Jersey, UK, in order to take his deposition. The court granted us the ability to submit that letter. We provided it to the other side at the exact same time that the court received it as well. The court did not rule on it immediately. The court actually asked alternative questions to both sides in regards to that letter. We provided responses to that, and at no time did the plaintiffs or appellants contest the nature of the categories were overbroad. They did not make any of those contests that they're making here today in this
Counsel,
appeal.
but for now and here, why don't you deal with whether in fact the testimony is necessary and directly relevant to why the contracts were?
Absolutely. And so, you know, and I won't disagree with my colleague here that it is crucial as the standard is which is required to show for this particular type of deposition. The defendant's position in this case is that prior to actually the decisions that they're claiming were the basis of termination, which came out in March of 2023, is that Mr. DePatron demanded that the contracts be terminated for the reasons and his own personal reasons based on the direction of the manner in which the marketing department was having marketing. The individual groups that they were targeting were personally, I guess, contrary to his own beliefs. They complained about this.
So this is what you want to depose him about, right?
This is part of one of the categories that we listed in the letter, absolutely, Your Honor.
And to determine whether, in fact, he actually controlled plaintiff.
Absolutely. And in fact, the issue is
That's particularly within Mr. DePatron's knowledge, though, right?
Specifically within his own knowledge.
What evidence came about from the last time you guys were here in discovery that makes it such that it's relevant to go to Mr. DePatron versus any of the other individuals you've already deposed?
Well, first, the individuals that we've already deposed have conflicting testimony, not only amongst the plaintiffs themselves, but also amongst the defendants. That's the first thing. Secondly, there was evidence withheld from us during this case in regards to the signal messages from Matthew Savage, and this was not before the court previously, and also two of them, one of them which is the one with Mr. DePatron himself, where he's disguised as the issue of why he's disguised has not really been determined yet. We have our beliefs, but and this is Matthew Savage testifying, stating, "We will go hard to terminate the contracts." And the issue is that happened before the actual audit took place, in which is the audit is which they're claiming is their main basis for termination.
Right.
Was there?
Please go ahead.
Was there a response to that message from
No, there wasn't, Your Honor. And the thing is this: if you look at the context of the message, this message wasn't something where it would seem like it would be the first time that they discussed this. This was essentially give me an update of what we've already been discussing previously. There is not a single message besides that one that was produced to us, and we don't have access to the phone. They originally did not produce the documents from his phone. Judge Borak ordered that to happen. Subsequently, we got the one message. We also got one more, which is another additional message that we did not have, involving Matthew Savage and Rebecca Banks, who said, first, we got rid of her as the employee. Our next step is to try to get rid of her and try to terminate the rest of the contracts. This all happened well before the audit, months before the audit, months before they had any of this information.
Right, you make the argument that Dupatron spiked the severance agreement with Ms. Schwartz, essentially.
I'm sorry, I didn't hear that.
Well, spiked is a term of art. In other words, he impeded the severance agreement that Ms. Schwartz had been provided by the plaintiff. Is that right?
Yes, we absolutely do believe. We believe that at the time, that's part of the interference that we believe occurred here. But first they decided to terminate the agreement, which was had 2 years remaining. They negotiated a severance amount. They claimed that they made the payment, and suddenly the payment was stopped, and they said, we're not paying you at all. Even though they claimed it was actually already sent, it had never been sent. So there was interference, and we believe Mr. DeBatron, who makes these decisions, we'll say behind the scenes, as the court's order stated, interfered with that particular issue as well. And
Counsel, one other argument you make is it's important to have some impeachment evidence concerning Mr. Lyons' testimony.
Yes.
Why is that crucial?
It is absolutely crucial because Mr. Lyons has been designated as the company representative of WIPH and has made several statements of fact as to what occurred here. So his credibility is absolutely essential to this case.
Was he at the meeting in New York about this litigation?
Yes, he was, along with Robert Kramer, Aidan Lyons, Peter DeBatron, Matthew Savage. I believe that was the extent of the meeting.
And Mr. Lyons' testimony was consistent that he only knew that this guy named Peter was in these meetings. He didn't know who he was. Is that correct, or is that a misstatement of?
That is an absolute correct statement, and we went over that extensively in his deposition. Mr. Lyons claimed that even though he had met with somebody once a month for 3 straight years named Peter, he doesn't know who Peter DeBatron is. And in fact, the additional evidence demonstrated that Peter DeBatron was the individual that actually got him the job in the first place.
You got that. You have that in your brief. Thank you very much.
Thank you.
Any other questions? Thank you.
Your Honor, just very briefly, with respect to the procedure, if you look at record site 317, you'll see that the trial court specifically said that there would be no further briefing on the content of the letter of request.
No further briefing, but could you have sent something, email to the court or anything?
We specifically emailed the court requesting leave to submit objections. And
Is that in the record?
The emails are not in the appellate record. We offered to submit them should the court want to see them.
Sir, were the 5 areas enumerated in the letter of request, were those areas identified by your friends in their motion papers when they sought the alternative relief?
They were not. In fact, in the motions papers, there wasn't even reference to Mr. DeBatron's marketing beliefs and the like that are centrally at issue in their brief. But I want to turn briefly also to the question of...
That's not a surprise, right? They talked about that on the last appeal, right?
But it's not a surprise, but again, it wasn't the basis on which they sought the letter of request. So we weren't heard specifically on any of those topics because they weren't set out anywhere in the brief, much less a draft letter of request.
I believe Judge Borak requested additional briefings from the parties on the record, page 317.
What he asked for were counsel affirmations with single-sentence responses to specific questions that he set forth, none of which had to do with the topics in the letter of request. But I want to briefly touch on this question of ulterior motive, right? The idea that they want to seek his deposition because they think behind the scenes he wanted these agreements terminated. This is a breach of contract case and a fraud case against them about their conduct. Whether there's an ulterior motive is irrelevant. It's not a question that's even at issue in the case. So the idea that they're now trying to seek a...
Well, it's relevant to the... Sorry, go ahead.
No, the general idea of pretext undermining their reasons for breach. In other words, that they ginned up some things that weren't really breaches because they had these ulterior motives. I mean, that's,
Under the contracts, though, we are entitled to terminate if there is a breach. So the only question is, did they in fact breach the
Well,
contract?
that's not really the only question. The question, again, is whether there was a pretext for you to say that they breached to terminate the contract because De Putron didn't like the direction of the marketing.
Respectfully, I disagree, but even were that the case, Your Honors, they've spoken to Dorton's chairman, general counsel, 2 corporate representatives for both entities, a board member of one of Dorton's affiliates. I mean, we are talking about the individuals to whom these supposed demands would have been made. You will find nothing in their brief or in the records suggesting or confirming that those statements were ever made.
Well,
There's nothing in
from
the
what I
record.
saw in the record, the allegations were that those individuals were not empowered to make certain decisions, and everything had to wait until De Putron was back in New York at certain board meetings.
That's not a correct recitation of the record, Your Honor. In fact, every single senior officer and board member, when they were asked more generally about Mr. De Putron's supposed influence, which itself is not a relevant issue, what they said is, no, we are empowered to make those decisions, and only we are empowered to make those decisions. And in fact, Mr. Freeman below conceded that the termination decision was a company decision that was made by the board and the officers of these companies. And they have sat and they have testified, and there's no gap in the record that Mr. De Putron has been shown to be able to fill.
Thank you, counsel. Thank you both. People v. Jones.
Good afternoon, Your Honors, and may it please the Court. Ben Perotin of KKL LLP, pro bono counsel on behalf of Appellant Mr. Jones. Your Honors, there are multiple reasons discussed in our brief why Mr. Jones' second-degree murder conviction should be reversed, but unless Your Honors have specific questions about other issues, I'd like to focus on the Orama topic today. The trial court failed to follow the strict requirements of People v. Orama and CPL 31030 in its handling of the third jury note. On the third day of deliberations, the court received a jury note which requested 3 things: video of the shooting, shot spotter, and diagram of the crime scene. Now, as Your Honors are certainly aware, Orama and his progeny are very clear about what needs to happen next.
But also, after that first jury note, didn't everybody agree that except for ballistic evidence, anything admitted, any exhibit gets to go to the jury? Didn't they agree on that?
Yes, Your Honor, they did agree to that. To that point in the respondents' arguments about that in their briefing, I have 2 responses. First, the agreement was a standard agreement that's reached in many, if not all, jury trials that allows parties to not reconvene to send specific exhibits back to the jury. For example, if the jury requested, hey, we want to see Exhibit 3 again, the court could send Exhibit 3. Or, in this case, the jury note requested 3 things, the third of which was the crime scene diagram of the crime scene. There was only
We've recognized that that's appropriate as sort of a quote-unquote ministerial type matter, right?
Yes, Your Honor, but what...
So I guess how then did the jury note 3 implicate something other than a quote-unquote ministerial matter?
Well, I have 3 responses, Your Honor. First, what happened in response to jury note 3 was not actually what was contemplated by the parties' agreement.
Well, just so that we're clear, the judge did contact defense counsels, right?
Yes, Your Honor. The judge said on the record that he contacted defense counsels and they agreed not to reappear. However, that does not dispose of this case. Orama and his progeny are clear that that is not sufficient. The Court of Appeal...
Even in the cases of ministerial matters?
Your Honor, I don't believe this is a ministerial matter.
Okay.
So to get back to the Justice Higgitt's question, the 3 responses I had were, first, what happened was not contemplated by the parties' agreement. The parties' agreement was to not reconvene all the parties in response to ministerial notes. That's not what happened here. What happened here is the judge engaged in an ex parte colloquy with the prosecutor alone. That was not agreed to by Mr. Jones's trial counsel, and there's no evidence in the record that Mr. Jones's appellate counsel or trial counsel would have agreed to that. Now, to address Justice Higgitt's point head on, there are 2 reasons why this note was not a ministerial one. Looking at what the jury requested, the first thing they requested was video of the shooting. In this case, there were dozens of camera angles. There was 189 video files and hours of footage. What video constituted the video of the shooting was a disputed issue at trial. And what video was selected to play for the jury in response to this question could have had an impact on their decision. For example, if the jury watched just a 5-second clip where their muzzle flashes were coming from off the screen, they might have had a very different impression of the series of events than if the jury was...
But we're talking about exhibits that were all shown to the jury at the trial, right?
Yes, Your Honor.
We're not talking about anything that had not been already shown to the jury.
Well, in two responses.
Answer that question.
Yes.
Okay.
First, the video exhibits were all shown to the jury. Second, the record is not clear as to the issue of the timeline and the index. The prosecutor talked about a timeline or index that was possibly sent back to the jury in response to this note. In response
That was not what was sent back to the jury, right?
It's not clear from the transcript what actually was sent back in response to this note. I believe the record is not clear on this point, which actually highlights the importance of the ORAMA procedure in creating a clear record for Your Honors to review on appeal. In terms of even if all the videos were previously shown to the jury, it is still a material stage of the trial that the defense has a right to be present and right for notice and an opportunity to be heard.
Well, that's why I inquired about whether defense counsels had been called and told that there was this note regarding exhibits that the jury had already seen during the course of the trial, and they were.
Yes, Your Honor, they were called, but the Court of Appeals has found repeatedly that that sort of discussion off the record, even if it's reflected on the record, is not sufficient to satisfy the requirements of ORAMA.
If it is not a ministerial matter.
Correct.
And this was a ministerial matter of sending back exhibits that the jurors had already seen during the course of the trial.
Your Honor, I see that my time's up, but to briefly answer your question, I respectfully disagree. For the multiple reasons in our briefing, there were many videos, and this also required interpretation of what the ShotSpotter exhibit was sent back. This was not a mere ministerial matter where there was a specific exhibit called for.
Thank you, counsel. You have time in rebuttal.
Good afternoon, Your Honor. Joseph Tucker for respondent. I think this...
So, counsel, why should we condone this conversation happening with the prosecutor where defense counsel is not present and we're talking about exhibits that are being sent back to the jury based on a request?
Because it was a ministerial matter, Your Honor. What was sent back to the jury, the 3 items that were requested were the ShotSpotter, which they were given, the diagram, which they were given, and the video of the shooting, which was not given during Note 3. It was given during Note 1 when all counsel was present. After they discussed jury Note 1, they all agreed that if they ask for exhibits again, they do not all have to reassemble. They do not have to discuss it with counsel. They can just...
But there was a discussion happening. There was a discussion happening only with the prosecutor.
Only as to what exhibits they were asking for. And
exactly.
Yeah, but there was no decision made by what the prosecutor was discussing with the judge. He just happened to be there, and the judge said, I'm going to send these items in. And I think what counsel is doing is misunderstanding something that the prosecutor said. The prosecutor said, they've already been given that exhibit, Your Honor. And he said, that's the one with the timeline. That wasn't the one that I used in my summation. That exhibit with the timeline was Exhibit 35, which was already given to the jury earlier on. So there was nothing that happened during that discussion that was not ministerial.
See, that's the problem, right? Like, if you're having this conversation only with the prosecutor and defense counsel is not present, then we don't end up with a clear record of what is happening.
I think the record is clear as to what happened.
Okay.
I think if you look at it, and particularly if you look at the few pages, page 695 to 697, that whole discussion right there is only a few minutes long. And it's just a conversation where the judge says, I'm going to give them these items, and he says, Exhibit 35 has already been given to him with the timeline.
Well, I guess to your friend's point, why is there a discussion at all? And Justice Michael's point, why is there a discussion at all? There's an agreement which apparently is relatively common to allow the exhibits to go back without the need to reassemble the lawyers. Fine, but why is there this conversation?
Because he's there?
I'm sorry.
Because the prosecutor's there?
I don't know why the prosecutor was there, Your Honor. I just don't know.
No, but in answer to the question of why there's a discussion, is it because he happens to have the time to be sitting in the courtroom while deliberations are going on?
I think the court was essentially talking to himself while the prosecutor was there, and he was deciding what exhibits he was going to give to the court officer to then give.
So the prosecutor's there, the reporter's there, because that's the only way we know about it, right? Because it's transcribed.
Is that a problem then, that that a determination had to be made what was being sent back?
Because all he did was send back the exhibits that the jury asked for, and that's exactly what.
Does it take it out of it being a ministerial act when you're making a determination about what the note means in terms of what they're requesting, especially put that together with right after that there's a verdict?
But I think the important critical part is that the judge did not rely on what the prosecutor told him. In fact, at one point, the judge said, I'm going to send back the shot spotter, both the report, which was a 34A, Exhibit 34A, and 34B, which was the audio. And he said, they asked for shot spotters, I'm going to send it. He made the decision. It wasn't a decision that he inquired about with the prosecutor. It wasn't a discussion.
They just happened to be chatting together, and it just happened to be transcribed on the record.
I'll buy that, Your Honor. I'll accept that.
Sir, please. Sir, is there any ambiguity as to whether the jury was sent the timeline and the index?
No, you see, the timeline was a timeline that was developed by a tech at the DA's office, and it's a timeline that's on the bottom of the video. That was in Exhibit 35. That's part of Exhibit 35 that was admitted to into the evidence. All counsel agreed to that earlier on. The index was an index that the prosecutor developed during deliberations to help the jury. And one of the defense counsels, when the court asked, when all counsel were present, would you like them to give that to the jury so it can help them, one of the defense counsels objected, and they never gave it to him. So the index was never given to them. The timeline was part of an exhibit that was already admitted into evidence and no objections by counsel. So I think they're conflating the index and the timeline. They're two separate things. And after jury note 3, the judge did not give them any video evidence at all because it was already provided to them in Exhibit 35 and 36. 35 was 3 video portions put together with a timeline, and 36 was all the other video evidence that was put together along with the computer that was sent into them, part of the agreement with all counsel.
Thank you, counsel.
Thank you.
We'd like to address 3 things on rebuttal. First, opposing counsel just said that the court was simply talking to himself. The record reflects that that is not true. The DA weighed in at multiple points about which exhibits had been sent and which should be sent. Quoting from the record, Mr. Szyminski said, I have the shot spotter report, that's 34. There's an audio. I don't know if it's responsive, if they want the audio for the shot spotter or just written report. Then they go on, it was the prosecutor who actually flagged this issue for the judge. And regarding the shot spotter issue specifically, this case is very similar to People versus Dennis, where the jury note dealt with a request for the defendant's phone call from jail. There was both audio of the phone call and the transcript. The sister department of the second department found that that was not a mere ministerial request because there was uncertainty about which the jury wanted. This case is
uncertainty relevant if the agreement covers all of the exhibits that were that the agreement permitted the court to give the jury any and all exhibits that had been admitted into evidence?
Yes, Your Honor. The uncertainty still matters because it matters which exhibits are provided. While both exhibits may have been previously provided to the jury, the choice of which exhibits actually went back in response to a specific question can make a material difference in a trial.
Why does that make a material difference if the agreement is that any and all exhibits can go back to the jury?
The agreement was that any and all exhibits can go back without the parties reconvening, but that's not what happened here. The prosecutor reconvened with the court ex parte. Therefore, the agreement does not actually cover what occurred in this instance. That is where the prejudice came in, where the prosecutor was able to weigh in while the defense attorney was not. There was the brief discussion about off the record, but
No, I was just thinking. Go ahead.
There was a brief discussion about it being off the record, but as we previously discussed, that is insufficient. Now, for all these reasons and the reasons expressed in our brief, we urge the court to reverse Mr. Jones's convictions.
Thank you, counsel. Thank you both. Buckman v. 117 East 72nd.
Good afternoon, Your Honors, and may it please the court. Maria Barboris for appellants respondents. The lower court abused its discretion by enjoining the Article 9 UCC sale of respondent shares in the acknowledged absence.
Counsel, what's the status of the non-pay at the moment?
It is still pending. The briefs have been fully submitted. There's no decision. And again, this was initiated in 2023, Your Honor. It's been pending for 3 years, and respondent has failed to pay her maintenance for 4 years.
Getting use and occupancy pursuant to the non-pay?
We are not, nor has the court ordered an undertaking. So the status quo.
Had you requested UNO?
I did not request an undertaking, Your Honor. We did request.
No, I'm not asking.
Use
Have
and
you
occupancy?
specifically requested UNO?
Yes, it has been requested in the landlord-tenant action. Your
And
Honor.
what happened?
That is still pending. It was part of the summary judgment motion.
This
Also
landlord-tenant action was instigated by your clients, right?
Yes, it was, Your Honor.
So would you say you charted your course here?
Well, Your Honor, historically, the civil court was, the choice of the choice of forum because it was an expedited forum. No one expected that this would take 3 to 4 years for an adjudication.
Right. I mean, regardless of the expectations, now that you're already down that road, isn't that where we have to sort of reside?
No.
No
you
pun
don't have to
intended.
reside there, Your Honor. The legislature granted the co-op the right under the UCC Article 9 to proceed without judicial process. So it was entitled to.
Also, speaking of UCC 9, did you submit copies of the subject building's bylaws?
So, Your Honor, I want to.
Or the certificate? I mean, you got to, or the.
Sure.
Yeah, the share
That-
certificates.
The statutory right.
Is that a yes or no?
It's a little complicated. Okay.
I don't
because
understand. I'm curious about the yes or no. Did you submit those?
We submitted it in connection with the motion to dismiss. We
No,
did not
is it,
submit it.
is it in the appellate record before us?
It is it is in the court below.
Thank you.
Okay, and I want to explain why that did not happen. It was not challenged. It was the co-op statutory right to proceed with the UCC sale was not challenged in the complaint, and it was not challenged in the moving papers below. The challenge, in fact, I pointed out in my opposition that there was no such challenge, and then in reply, respondent said that we had the burden, which we don't. We don't have the burden to demonstrate anything on an order to show cause. I then submitted a letter response to the lower court pointing out that our declaration, Article 5, Section 5 of the declaration provides that lien, Your Honor. And I unfortunately put the wrong bylaws in as an exhibit to that.
Oh, right, from a different building, right? Yeah.
From a different building, yes. I was filing it at midnight, and that was inadvertent. The declaration is part of the docket below.
But it's not before us.
It is not before us. The body of it is in that letter that I submitted to the court. But again, the statutory right was not challenged by the respondent in her moving papers. She had the burden of demonstrating by clear and convincing evidence that she's entitled to that statutory relief.
Are you required to have it before us so we can make a determination on the issue?
Well, the lower court didn't make a determination on that issue. It wasn't before the court, and it's not before this court for that reason.
But we're trying to see if the court providently exercised its discretion. So that would help, I think. And you agree it's a provident issue, provident exercise of discretion standard, right?
Well, if the lower
sounds
court,
like it from your
if the lower court had relied on the fact that we hadn't established our statutory right, and its decision rested on that, then yes, I would agree. But that's not what the court did here. The court acknowledged.
It did what Supreme Court reflexively often does, which is defer to the civil court. And I know you're agreed by that, you say, because the civil court's not proceeding with the same speed that you'd normally expect in a non-payment proceeding, which is a summary proceeding?
Yes, Your Honor. It's been nearly 4 years that we have not received maintenance payments, and respondent does not reside in this building. Respondent has never used these apartments.
But it's not really a residence per se. It does not have a kitchen or anything that would make it a residential apartment.
No, Your Honor. My point is not that she doesn't reside. She's never used these apartments. She's never intended to use them. The interest in the apartments is solely commercial. After her husband vacated upon his retirement.
Then why wouldn't you change the CFO?
That is more complicated. It's not that we don't. They abandoned that request, and that's in the docket in their letter to the co-op where they say we no longer want you to amend it to be a medical office space. They pivoted because there is no market for medical office spaces.
But there's a market for commercial spaces.
But it was never a commercial space. It's either a doctor's office or a residence. There's no market for a doctor's office. It's actually more lucrative as a residence, which is supported by the record, including the broker's own statement saying that this has gone down 25%. The market has gone down. And then after that statement was given, respondent's brokers reached out and asked if it could be marketed as a residence.
I mean, this is a space on the Upper East Side. It's lucrative either way, right?
No, it's not. There are no market for these doctor's offices. It's lucrative as a residence. It's not lucrative as a doctor's office.
But it
Upper
has
East
been-
Side is not lucrative anymore, okay.
But it has been used as a doctor's office by respondent's husband for 50 years. So I don't know how, you can say it was always a residential office. The CFO was changed.
Well, a C of O only reflected one doctor's office. So it may have been used, but that doesn't mean it was legally used as a doctor's office.
But the question I think that Justice Chan is presenting to you is that it was changed, the CFO was changed to reflect 2 apartments only, right?
C of O always reflected a lobby, a singular doctor's office, and 1 residence. It was changed for that singular residence to then reflect the singular doctor's office to reflect a residence.
Exactly.
Yes, and
That was done by a different shareholder who has really nothing to do with this apartment, and it was based on that shareholder's architect.
No, it was based on the fact that there's always been only 1 doctor's office in the certificate of occupancy, and the Department of Finance noted that apartment 1E, the one that was changed, was the commercial space.
It was without notice to the Buckmans, correct?
That was without notice.
Thank you, counsel. You have time to rebuttal.
Good afternoon, Your Honors. May it please the Court. Jackie Aiello from Smith, Buss, and Jacobs on behalf of plaintiff, respondent, appellant. The decision being appealed from both extended the TRO, but also separately issued a stay of this case and the related action. And the basis for issuing the stay was seemingly unrelated to the elements of a preliminary injunction, but rather based on the fact that this housing court action was now gearing up for summary judgment at the time and has, of course, since fully been briefed. And so—
You got your preliminary injunction?
No.
Right? You did not?
No, it was not great. The decision states that the TRO was extended and that a stay was in place until the housing court—
That sounds pretty good. I mean, how are you aggrieved by that? How are you aggrieved by that?
How were you aggrieved by that? So if we were to receive the preliminary injunction, we would be able to proceed with this litigation through the end of the litigation without a concern that the apartments would be sold out from under Ms. Buckman.
You didn't cross appeal.
We do cross appeal.
I'm sorry, I misunderstood.
That's okay.
Okay.
So yes, so we are aggrieved in that sense as we did not receive our preliminary injunction. And had we, then we would have that through the pendency of the entire case, as opposed to this decision, which seems to indicate that once the housing court matter is decided, the TRO will be lifted, the stays will be lifted. And so the stay was put in place because of the potential for an inconsistent determination between the housing court matter and this matter. And an inconsistent determination would have dire effects. If, in this case, for example, the TRO was lifted and the apartments were sold, and the housing court the housing court judge determines a month from now or a month after an auction that we had a basis to withhold the rent.
Well, that's why there's a stay.
Correct. And I'm saying—
So that's good.
Yeah, it is good. It is good. I'm saying, should the TRO be lifted pursuant to the appeal the co-op's appeal.
Then
here.
you would be.
Then we would be aggrieved, right? So I'm saying that the motion court properly put in a stay and extended the TRO.
Right.
I just want to speak briefly about the balance of the equities, as I think that's the most important aspect here, which is, as was touched upon by the court when counsel was arguing, Dr. Buckman used this apartment for over 60 years as a doctor before he retired and then passed. Prior to that, this same apartment was still used as a doctor's office from the time of inception of the building, from 1928. There is nothing in any C of O, there's nothing in any proprietary lease, there's nothing in any I-cards, there's nothing that indicates that 1W was anything but a doctor's office ever. And there's, more importantly, the C of O's.
But the CFO was changed, right? And I think 2017, and then your clients learned about it in 2018, and then nothing was done between then and this action, right?
The 2021 action was the first action commenced.
Right.
So that was the first time that they did something about it. Dr.
Also,
Buckman.
the other unit that was owned by Dr. Buckman is SR1C, is that right?
Yes, Your Honor.
That's not even mentioned in the CFO, is that correct?
It's not mentioned in the C of O. Neither are any of the other servants' rooms. There are 7 or 8 servants' rooms in the back of the building on the first floor.
There's 7 of these types of units, servant rooms?
7 or 8. I don't know exactly how many, but there's a number of them. One is actually used as the superintendent's office, and some are owned. There's actually a set of board minutes where the board talks about wanting to purchase 2 of those servants' rooms, put them together, and use them as
storage?
No, as a residence for staff. But of course, now they take the position that it's only storage when it comes to Ms. Buckman and how she can use it, how she could sell it, how she could sublet it. There's nothing in the documents in the entire record that support that position related to it being storage, and whether 1W is the residence that now they claim it is. The C of O has always mentioned one residence, but the co-op's superintendent lives on the first floor. And there's nothing that says it was 1E and not 1W. That was the doctor's office. They just decided that once they decided Dr. Buckman's done practicing medicine, he was retiring at the time. We don't want doctor's offices anymore. We'll change the C of O, and they will have to, I guess, deal with the consequences. And here we are.
Well, is it accurate that it's more lucrative to have residential space there instead of a medical office?
To Ms. Buckman? Do you mean?
To anyone.
No, we don't agree. We don't agree. And honestly, it is not for the co-op to decide how Ms. Buckman chooses to sell the apartment. IRC 216, if they want to use it as residence, they can, but they're not required. The proprietary lease permits the use as a doctor's office. The motion court had also determined that to the extent there was a limitation in the lease about not being able to use it as a doctor's office unless you lived there, that has been waived because it was used that way for...
It was honored in the breach for 50 years, is what your argument is.
Yes.
Okay, thank you.
Thank you.
I want to address a couple of points that were made. One, there was no finding of waiver. Merely that cause of action survived a motion to dismiss. That's the breach of the covenant of good faith and fair dealing. I want to go back to SR1C, okay? Since we're discussing what is and isn't on the record, none of the facts just espoused by appellant are on the record, okay? The
It's
board
definitely,
minutes.
I mean, didn't the Judge Morales Minerva found that the SR1C was not in the C of O? She found
Yes,
that.
I'm discussing the board minutes, discussing the two, or the fact that, we have not permitted it to be sold as a residence. I want to go back to what actually is alleged in the complaint, which is the 2017 amendment to the certificate of occupancy changed the use and occupancy of both apartments, right, 1W and SR1C, from medical office to residential. That is the only harm that's alleged here. That's the only thing that we're alleged to have done. And SR1C has never been on any of the certificates of occupancy for 100 years. And so there was no basis.
That doesn't mean they couldn't have been harmed by it if, in fact, they were allowed to use it as a part of their doctor's office, notwithstanding the absence of anything showing up in the C of O.
Well, they're permitted to sell it together, and it's permitted to be used as storage as it always was. It was not, they were not permitted to ever use it for the practice of medicine. Dr. Buckman bought it to use to store medical
No,
records.
I thought he bought it to use as an administrative office.
Sure, as an administrative office, but not to.
An administrative office is not necessarily a storage room.
And
in fact, usually not.
Sure, but there's nothing on the record that demonstrates what the board will and will not allow it to be used if it's sold. There's absolutely nothing on this record that discusses that. The entire harm in the complaint alleged is that the 2017 amendment to the certificate of occupancy impacted SR1C. It had absolutely no impact on SR1C, and there's no basis to not lift the TRO, at least with respect to that one office.
Thank you.
The court has afforded me 2 minutes on rebuttal. I don't think I'll take that. There's just one minor thing I wanted to address, which is the very last point being discussed, which was SR1C. Council acknowledges was not purchased as storage. It was purchased as an administrative office. And I believe in the record there's a picture of the space. It shows that it was an administrative office. There's a desk, there's a couch, there's art, there's a bathroom. It was approved based on the letter that was submitted by Dr. Buckman, I believe in the 70s, advising how it was going to be used. And it seems that the co-op is acknowledging that just because it's how they purchased it and used it for 50 years, that the co-op can do what they wish and change it at will whenever they want. So we rest on our papers and ask that the TRO be that the decision be affirmed, and with respect to our cross appeal, that with respect to our cross appeal, that the determinations with respect to the merits on the two claims that the motion court had determined was not, there was no likelihood of success, that be reversed.
Okay, thank you.
Thank you.
Thank you both. Marinac v. Marinac.
Good afternoon. My name is Marianne Marinac. I am the appellant appearing pro se.
Can you put the mic closer to your mouth? Thank you.
The order on appeal contains the legal basis for its own reversal in the judge's own words. The court imposed a filing restriction on me, citing cases that require meritless litigation motivated by spite or ill will. Then on the same page, the court wrote, "The court at this time does not find the motion frivolous, without merit, or as a way to delay the proceedings." Those two findings can't coexist. The restriction had no legal foundation. The order cites my behavior, but identifies no conduct. The only behavior in this record are my two recusal requests of this judge. Punishing a litigant for requesting recusal is retaliation, and that's exactly what happened with this motion and has continued to happen over the last year. The matrimonial defendant has not participated in this case for years. He fled the country in late 2022 and then stopped all communications with his legal team a few months later. There's a bench warrant out for his arrest, and I have overseas child support case through the Hague Convention on the International Recovery of Child Support. This motion concerned a large amount of money transferred by my spouse to a man named John R. Gorman. He's supposed to be the respondent here. I submitted bank records, wire confirmations, and government records of what I found, and the court addressed none of it. The court called the motion duplicative without explaining what it duplicated. The same judge authorized this motion to be filed on October 24, 2024, the first time I appeared before him after my prior judge was retired. He cannot authorize a motion and then deny it, stating it was duplicative. The pattern is on the record. Mr. Gorman and his counsel skipped multiple court dates, even court dates that his counsel herself chose. And the judge looked the other way each time, even when they specifically in writing insisted that Mr. Gorman had to appear. He skipped 2 court dates, and on the only one where he showed up at the courthouse, he sat in the back of the gallery watching instead of being sworn in at the table. So this has been a pattern that has continued here. The opposing counsel made just comments about me that were not true. She stood up in court and said I had been making disparaging comments against her and her client and her firm. None of it was true, but the judge turned to me and said, "You have to stop disparaging people. Let's keep things professional."
Thank you, Ms. Marinac. Ms. Marinac, I noticed I couldn't find some of the authority that you cite in your brief.
Yes, I know.
And you really need to double check that. And
Yes.
particularly, I'm not saying you did, but particularly if you use AI, if anyone uses AI in a court, whether they're a lawyer or not, they have to check the authorities.
Yes,
So
yes.
that, I'm just telling you that for future reference.
Yes, I do know that, and I've unfortunately, because I've had this judge, I've had to file many things. I feel like I'm living in the first department and really learning the procedures. So my next appeal, I have triple checked every case because I wrote this out and then realized I had to put cases in, and it's hard to search when you don't have Westlaw or Lexis. I noticed that one of the cases that fit in perfectly with my authority turned out to be a Georgia case and not a New York case. But when I looked for the citation online, I got a citation that doesn't go with the case, actually. So I do realize that. But
Okay,
I
thank
just
you, Ms.
wanna say-
Marinac. I'm just letting you know for future reference, and thank you for your acknowledgement.
Okay.
Thank you very much. We have your papers, and you'll hear from us
Can I
with the
just say
decision.
one more line?
30 seconds.
Okay, the most important thing is that of all this is to be reassigned to a different justice.
Well, I'm sorry.
The most important thing is that I be reassigned to a different justice, and that's what I'm asking here. Not just turning over the decision of April 1st, but to be reassigned, because he's not going to recuse and the retaliation has not stopped. And if you would read the other appeal, you will be absolutely shocked. That's all. Thank you.
Ms. Marinac. People v. Gero. Please.
Good afternoon. Isabel Patkovsky on behalf of the Legal Aid Society for Mr. Cuello Garrido. We are respectfully asking for a modest sentence reduction because of Mr. Cuello Garrido's documented physical disabilities and because of DOCS's documented record of providing, quote, abysmal health care.
Didn't he have those documented disabilities at the time of the crime underlying this?
Absolutely, Your Honor, and we're making a very specific argument. We're not suggesting that his disabilities mitigate the crime. What we are saying is that in light, particularly of the recent report by Senator Salazar and a lot of reporting that I'm sure Your Honor.
Okay, let's talk about in the light of what actually happened here, right?
Yes.
We're talking about your client was in his 30s at the time, right?
I think that's right, yes.
And we're talking about a 7-year-old child that was sexually assaulted to the extent that surgery was required, right? What's excessive about this sentence here, where it's not even the maximum, right?
It's not the maximum. And what's excessive about it is in light of the specific disabilities that Mr. Cuello Garrido has.
Those disabilities did not keep him from inflicting the damage that he did on the victim here, right?
They did not, but they do make a 10-year period in New York State correctional facilities tantamount to an inhumane sentence. DOCS provides, and again, this is quoting the Salazar report, dismal treatment. They refuse or disbelieve patients' pleas for help, resulting in preventable deaths. There's a staggeringly high.
What are you citing from? Is that a case? Is that
a
law?
report that I would ask that.
Is that law?
No, it's not
Okay.
law. But I think it's important for the courts in this state to understand that the place where they're sending people, even for able-bodied people, is incredibly dangerous. I'm sure
You're not talking about his sentence as per this crime that he was, you're just talking about he should not be in the jail because it's really not healthy for him.
it's not safe for him, Your Honor.
Or safe for
What about
him.
the health of the child whom he damaged?
The health of the
We also have to consider that in considering whether this is a fair sentence.
Yes, Your Honors should consider all the circumstances.
So the judge who imposed the sentence had that information in front of him and concluded this was a fair sentence given all of that. Why should we deviate from that?
Because respectfully, Your Honor, that's true in every single excessive sentence case. We are bound to the record that was before the trial judge. I cannot introduce new information.
Right, but the question is whether what transpired was excessive, right? And if you look at it and you have to weigh what occurred, right? We're talking about a 7-year-old who came from a place of the 7-year-old also being very in a vulnerable position. That 7-year-old, which your client knew had been abused by someone else, then preyed upon her to the extent that the damage caused required surgery.
May I briefly respond, Your Honor?
That's not up to me.
Please.
Thank you. We, of course, agree that this crime is horrific, and that's not a question. That's why I'm not talking about it, because there's nothing to say. We agree.
Something was required to be said about it, right? Because you have to weigh both of those
course,
things.
Of course. But
and what you say in your brief, actually, is that there's needless cruelty being imposed upon your client versus the cruelty imposed upon this 7-year-old child.
we don't say it's versus that cruelty. We do say that in our society, even people that commit the most horrific crimes are not supposed to be physically abused. They're not supposed to be exposed to
Is there any
dangerous
evidence that he's been
conditions.
physically abused?
Well, he has been, Your Honor. He's already been badly assaulted
In the
and
record
outside
before
guards.
us, is there any evidence of that?
Well, no, because the record before you is before he went to prison.
You have time in rebuttal, counsel.
Thank you.
Good afternoon. May it please the court, Skylar Siebert for the people. Shortly after becoming a foster parent, defendant raped his 7-year-old foster daughter on 2 occasions. The second time, so violently, she required emergency surgery. That is the sole reason the rapes came to be known to law enforcement. He was indicted on 2 counts of...
The sentence here, well, first let's back up. Let's talk about the waiver. In your analysis, is this a valid waiver that precludes us from even looking at the sentence?
Yes, Your Honor. The court's oral colloquy, with the presence of a Spanish interpreter, tracks the model colloquy. The defendant stated he understood the waiver, he had the assistance of counsel.
Let's talk about the Spanish version. Is there anything in the record for us to rely on that he actually did have a Spanish version before him?
Yes,
a
Your Honor.
translated Spanish version.
Your
of
Honor,
the
the-
written waiver, sorry.
I understand. Your Honor, the prosecutor during the plea proceeding did state that she provided the documents, being the written waiver, in a Spanish copy and an English copy to defense counsel. So, and even when he did sign the written waiver, he had the Spanish interpreter right there with him when he consulted with his attorney. So therefore, the waiver is valid, and the defendant did his...
The written waiver that we have in the record, though, is English, right? It's in
Correct, Your
English.
Honor, yes.
Is there a prohibition on us considering the circumstances of a defendant's confinement in gauging whether a particular sentence is excessive?
Well, Your Honor, I understand defense's argument that they are setting forth, but I would note that this is more appropriately handled by docs themselves if this is the situation that defendant is experiencing. He is not the first sex offender to be in prison. There are certain state prisons in New York that can handle sex offenders.
Well, I think a part of the argument, though, is given his frailties, his medical condition, his cognitive issues, that it puts him in a more susceptible position. Should we consider that?
No, Your Honor, I don't believe you should consider that. I don't think that that argument should be weighed as a factor in determining whether his sentence was harsh or excessive. And as you noted earlier, he suffered from these medical issues since 2019, and it didn't prevent him from raping a child. So it was before the sentencing court. The sentencing court considered the defendant's medical issues at length. The sentencing court extended and adjourned the sentence to a later
We're
date.
not bound by what the sentencing court considered, right? We can make our own independent determination of what's excessive, right? By case law?
Yes, Your Honor.
Okay.
Yes, I would just finish by saying that, again, all of these factors that defense sets forth now were before the sentencing court and were considered at that time. In light of these circumstances, I rest on my brief if there are no further questions. Thank you.
I'd like to briefly address the appeal waiver, but first I do just want to point out that Mr. Cuello Garrido will certainly be a lifetime registrant on the sex offender registry. He will be under 20 years of post-release supervision. He's not getting away with this crime. Our position, and I understand that my adversary does not agree, but our position is that 10 years of prison is unnecessarily cruel, specifically for someone in this frail physical condition.
Just how you, and that is certainly not a frivolous argument at all. How, though, do we gauge an individual defendant's mental or physical health in relation to the correctional facility in which he or she has been sent, and gauge whether the sentence is excessive?
I think
that seems, sorry,
please.
Let you answer. It just seems like a sort of a fact-driven inquiry that we may not be well suited to undertake.
Unless I misunderstand my adversary, she's not disputing any of the facts on the record about his physical disabilities, his poor health. And the unfortunate fact is that Docs is not, he cannot rely on Docs to help him, because Docs, in many cases, is the actor that is subjecting people to inhumane conditions. I'd remind your honors that Robert Brooks was murdered in a medical room. That is the state of medical care in state prisons. I know my time is up.
May I ask for 30
Please,
seconds?
of course.
For,
Go ahead.
for the waiver.
Thank you very much. Two points on the waiver. First of all, just a quick clarification. The prosecution did not specifically say they provided the waiver in Spanish. They said documents in Spanish. We also believe that the waiver is invalid for two separate reasons.
Well,
First,
wasn't trial counsel aware of whether it was offered to him in Spanish?
I don't know.
It definitely was the case that a Spanish interpreter was present.
Yes, there was a Spanish interpreter present. The first problem with the colloquy and the written waiver is that it implied that Mr. Cuello Garrido was waiving the right to an attorney. Now, I understand this department has not issued an opinion on this argument, but I would respectfully remind your honors that the second department repeatedly has invalidated waivers on this basis, and it doesn't seem right that Mr. Cuello Garrido is barred from making an excessive sentence claim in this department when he could make it in the second department. Our second argument is that the judge told him the waiver was required. Now, I agree with my adversary is that there were some statements further in the colloquy that perhaps cut the other way. However, this statement was particularly harmful and particularly misleading because immediately after, the court said, and SORA registration is also required. And SORA registration is the perfect example of a right that you actually can't bargain away in plea bargaining. It just follows automatically from the plea. So the court really was implying that the right to appeal was a right that was waived automatically by the plea. And even if the court later said something to the contrary, at the very least it was muddled. Thank you.
Thank you, counsel. Thank you both.